Smart Legal Contracts Masterclass. This session will be recorded. Please, cameras and audio off. There will be Q&A following the presentation, so include your questions in the chat. Firstly, I acknowledge the traditional custodians of the various lands on which we meet today and the Aboriginal and Torres Strait Islander people participating in this webinar. I pay my respects to elders past, present and emerging, and recognise and celebrate the diversity of Aboriginal peoples and their ongoing culture and connection to the lands and waters of New South Wales, Australia. I am Natasha Sinomarkovic. I lead the Australian Society for Computers and the Law Future Law Work stream and am also on the Society's Managing Committee. We are a cross-disciplinary think tank promoting sustainable law, technology and society through education and policy, and are privileged to have His Honourable Michael Kirby as our long-standing patron. As part of our Future Laws program, we have run expert panel sessions on future contracting and rules as code, a global movement to deliver law and policy in human and machine readable form natively. We also helped form the ANZ Rules as Code Community of Practice, together with Code for Australia and La Trobe University, and ran a series of free Rules as Code masterclasses attended by a global audience, which we're very proud of. As we all know, digital technologies are changing how we work, how we consume, how we do business throughout the global economy. The practice of law and contract drafting is also changing. Next-gen contracts, aka smart legal contracts, will incorporate executable code. And with growing adoption of distributed ledger technology, we expect to see a shift across all industries towards smart legal contracts. So it's a real privilege to have Natasha, Blycha and her colleague Jacques Giuffre with us today, experts in the field of smart legal contracts, rolling up their sleeves to deliver this masterclass. Now for some quick bios. Natasha Blycha leads the Global Digital Law Group at Herbert Smith Freehills, with team members in the US, UK, Europe, Africa, Australia and Asia. She specialises in smart legal contract advisory and creation and distributed ledger technology. Natasha advises on regulation and governance of digital assets, platforms and applications, digital ethics and human rights policies. Okay. Natasha has received multiple awards, including Thought Leader of the Year at the Lawyers Weekly Women in Law Awards 2020 and Innovative Individual of the Year at the Financial Times Innovative Lawyer Asia Pacific Awards last month. A mouthful. Congratulations, Natasha. Well deserved. Jacques Giuffre is Senior Associate and colleague of Natasha's at Herbert Smith Freehills, advising in a variety of areas including information technology, IP, infrastructure and general commercial matters. Jacques has a focus on technology, outsourcing, IP ownership and licensing, cloud-based services, information security and privacy. A quick reminder to everyone, keep your video and audio off. Natasha, over to you.
Thanks so much, Natalia. Jacques, do you want to stick our slides up? Wonderful. Yeah. And on to the second page, please. Okay, so that's just an agenda to set the scene. We're going to, when we were asked to do a masterclass on SLC drafting, we wanted to be quite fulsome in the way that we approached that. So we're not just showing you how to draft, in the technical sense. Probably that's the part that people are most interested in and is probably going to leave you the least satisfied. We also wanted to talk about taking instructions for smart legal contracts, which is actually quite different to what lawyers have predominantly done in the past. And we also wanted to talk about drafting smart legal contracts in the nuts and bolts Blackletter law way at the end of the technical components in the middle. So expect to see those three parts and then we'll have time for questions afterwards. Next slide, thanks, Jacques. Okay, so what I thought we might do here is just in case there was anybody new to smart legal contracts on the call, which I don't think is many of you, but we'll give it a crack. I want to define smart legal contracts and then I want to do a why, and then I'm going to talk about these three big gateway questions. So first of all, some people use the words smart contract and smart legal contract interchangeably. I tend not to do that. And the reason is that smart contracts are self-executing code on a blockchain, and oftentimes they don't tend to have natural language associated with them, and they're really not the digitized version of that thing lawyers do in law firms and in-house legal departments. Smart legal contracts are the digitized and automated form of legal agreements. So they are the next iteration of legally binding agreements, but in a form where there is code within those legal agreements. So you may see a legal contract that contains smart contracts within it. That could be something that's called a smart legal contract. The reason that smart legal contracts are incredibly important are that the legal industry is going through its own digitisation. It's not dissimilar a journey that you would have seen through the banking industry, although some would say with DeFi, the banking industry is probably further ahead on its journey. And what you saw in terms of a transition from notes and coins to noughts and ones is the same thing that's happening to the legal industry now. And really, unless you've sort of been under a rock and not know what the benefits of automation are, we know, and we've certainly had hundreds of conversations with clients, is that if somebody was able to produce the right tools and platforms to establish smart legal contracting for all, these are the reasons that the why for smart legal contracts. They save money by performing operations themselves. That's pretty much the biggest one. They tend to provide a heat map for business performance. They're like the Strava map for those cyclists out there of how your contracts are performing. The big change, the seminal change of smart legal contracts is they have the ability to perform post-legal execution. If you start to look at them, they're basically a familiar tool that's a structured data packet that's full of rules that you can use as a gateway to AI. They are able to learn your business. So, you know, if it's a client, if you're coming as a lawyer, it's a client, or you're coming as a lawyer in an in-house department, you're able to have the contract itself act as a brain, and collectively as a brain that is able to understand the performance of your business relationships. So starting to think of the contract not as a legal tool, but as a tool for business to be better able to understand its performance. The reason the contract is so powerful is because contracts are ubiquitous, they go everywhere, and contracts can interact with other parts of digitized systems. So your ERP backend systems, your CRM systems. Once we are able to fully digitize contracts, and as you'll see, create oracles for contracts to other sources of data, you're able to have interoperability between the backend systems that already exist in business. And that also has risk reduction and compliance reduction costs. So there's a lot of cost savings and removal of frictions. So that hopefully, by the time you get to the end of this presentation, you want to think about a contract. It's a familiar tool. It's something that's already there, which will be a very useful co-owned digital asset that will allow us to make good headway to collecting data and being able to use AI in a structured way going forward using contracts. So 3 things: legal certainty, adoptability, and cybersecurity. I have fortunately or unfortunately been talking about smart legal contracts for a number of years now, and if I was to only say 3 things in a presentation, these are the 3 big things. For smart legal contracts to really take off, we need to make sure that the legal veracity or the 4 walls of the legal contract are not endangered by the act of digitisation. So a legal contract needs to retain its legal certainty. That is a gateway requirement, which is why we have spent so much time in looking at the actual Blackletter drafting to support it and the tools and platforms that underpin the digitised contract. The next one is adoptability. And this will be a challenge to most people, because I wonder what we're going to show you now. You will, ask the question to yourself, do you think this is adoptable? I would say that smart legal contracts are only going to be adoptable in the future where they are exactly the same the way that our banking systems are. You don't need to be a coder in order to do your banking transactions. And I don't think smart legal contracts will be fully adoptable if it requires the profession or lawyers needing to become either pseudocoders or coders for these products to work. So adoptability is a big gateway question around the products and tools. And I know that there are some products and tools coming, which we can't show you today, which hopefully will make that adoptability point a little easier. Last one is cybersecurity. And I think that the way that a contract, the contract Jacques spoke about earlier, the one that's sitting in your drawer, legally breaking a contract was quite a difficult thing. I couldn't just tear up a piece of paper to break your contractual obligations. But when we digitize contracts, we introduce a new method of creating risk, and that's the cybersecurity of the platforms that actually underpin those contracts. It's the plumbing. And if I will just take this opportunity to go in a little deeper, because from my perspective, if people here take anything away from what I would be concerned about around the adoption of smart legal contracts, is I want you to be really, really mindful of what plumbing you use to underpin your smart legal contracts. And this is for this banking grade, enterprise grade cybersecurity question. And I want people to be really careful and thoughtful around their clients' data and organisational data to make sure that that is protected. What we've done is some of my colleagues and Dr. Mark Staples and Ariane Garside, Susanna Wilkinson, and with the help of some others, including Jacques, actually put together a protocol for infrastructure to support what we would say is critical infrastructure for smart legal contracts. So that's an acknowledgement that legal contracts are really important. They're critical assets, so they need to be secured with critical infrastructure. And I'll just rattle these off is some of the things to think about at your organisation or your clients. And they are confidentiality, privacy, and permissioning. So if you're going to use plumbing or a platform for your smart legal contracts, be very careful about the hosting. And I'm going to bang on about that throughout the presentation. The parties themselves need to be able to manage and control their data. And you want to have sort of robust and rigorous identity management, because you can't have, you have to have privity. You have to have people being able to see the contract who should only be able to see the contract. It's a confidentiality point. The other one is access. So those of you who are in digital assets will have been hearing lately about certain parts of the community being debanked. When you start going down thinking about the plumbing for contracts as they become critical legal assets, you should also consider that it's possible, if we don't have rules around this transition, that people will be able to be decontracted in the future. So there's probably some access requirements that countries will need to put in place, that if other requirements are met, that any kind of infrastructure should be able to host as many contracts as possible without sort of I suppose, making value judgments about the participants who want to put their contracts on, not the content of the contract itself. No unilateral change of contract without counterparty agreement. That seems pretty basic. The other one I touched on before is data. You only want to have a platform that's recorded. This is a big one. You only want to put your contracts on plumbing, which is keeping the minimum amount of data around the contract, because think about the platform as not just seeing your contract, but being able to see every contract that runs on the platform. And for those of you who've got concerns about data privacy, I would suggest that the heat map of the economy is very powerful if you can see the workings of the inner contents of contracts everywhere, even the metadata. Last one, cybersecurity, which I've already touched on, and that's just to say, you want to be sort of meeting ISO 2701 requirements or equivalent, and that needs to be banking grade. Yeah, I think that's pretty much it. Oh gosh, how could I forget? If you think it's important not to lose your, you don't want your electricity turned off if you just don't pay your bill. I think it's also really important that you don't have suspension issues on your contracts. Portability, interoperability, reliability, and availability. Also, with your mobile phone, you want to change your number. You also want to be able to change your platform with your contract. So there's some pretty big, again, critical infrastructure points there. And of course, seventh is your legal requirements, that all those privacy law requirements, data collection, are met by the platform. So please take that away. Don't just put your contracts on a solution that is a big honeypot. Actually think about the underpinning platform for your smart legal contracts. So now I'm going to, Jacques, if you could just turn the slide. I might just share my screen. This is about taking instructions for smart legal contracts. So this is probably the true start of the masterclass itself. A lot of the platforms you will see engage in what I call, so let's just be absolutely clear. No one has really quite nailed a tool and platform for smart legal contract adoption yet, but they're coming, and they're coming thick and fast. They're just not quite here yet. And one of the reasons that they're a bit difficult is around that adoptability point, and that's because there is what I call the unified method, or you might see written is the unified method, where the term in the contract itself is actually delivering the content or the fields of information which you want to have automated. So one of the things I'm going to show you in taking instructions now is to just sort of turn your mind a little bit to what we call the paired method, which is where I say, look at your contract. You're going to go and sit down with the client, or you're going to draft your own contract, or you're going to draft a contract for your organisation. When you draft that contract, think about some totally new questions about where you'd like to add automations to that contract. Where can I get to those business opportunities where the contract can start to perform itself? And to date, what I see most people do is they're really linear in the way they ask that question. They literally think, well, I can perform a payment. So they go and look through the contract for a term which says, if this happens, pay this amount of money, or if this is late, do this. Whereas what I want to show you now, if I just can share my screen for a second, is to be much more creative in taking instructions around what clauses can actually be automated. So this I'm calling a smart term sheet as a method for collecting information about what you'd like to automate in your smart legal contract, but it's not really smart. I guarantee you these things will become smart in the future, in that they will self-populate and automate and connect into your full contracts. But right now, this is just something I've cooked up overnight to try to look at this second, well, it's actually the fourth column, the terms smart. And these are some of the questions I think people should think about asking when they want to add an automation. What I want you to look at is the natural language here is actually just a list of the parties. And on the column, which is the smart terms, when I'm taking an instruction here, I will say as a lawyer, okay, what could I do here that I could add an automation that will increase the benefit, reduce frictions in the real world, or connect my contract to other sources of information. So in this instance, what I've done is I've gone, oh, okay, I've got all this information here. Why don't I add an automation here if I have an ROI or I have a cost benefit in doing so, which is to monitor the ASIC register. Oh, can I enlarge your sheet bottom right, please? Just a second, Phil, I'll try. Now you're going to see how rubbish I am at my actual tech on my computer, which is my secret shame. No.
The plus, the tiny plus at the bottom. Yeah.
Thanks, Jacques. Is that better?
Yep, that's good.
Phil, are you happy? Okay. So here what you can see is these are just party names. So this is not going to look, the example Jacques is going to give you is the sort of the very clear, simple version where you can see very clearly something should be turned into a smart contract. The ones I'm showing you are the get creative and start thinking about what else can be automated. So here, if you read this, as I said, it might be for your particular organisation that you say, or your client, that we've got ourselves bitten previously. We've got a risk profile that one of our parties have gone insolvent and we didn't realise that happened. It's had knock-on consequences. I could actually choose to add an automation here where I could make the data source an API provided by ASIC, and I could make the trigger events every 6 months to actually just check if the corporate status from the ASIC API So the other thing I can look at here is I can say, well, what else would I need to automate? I'd probably have to draft up a precedent notice to automate as well. And I also should ask this question, do I want my automation to be binding or not? And definitely from doing this for a while, I would say most of the time you do not need your automations to be binding, but you do want your digital terms to become part of your contract. So what I'm hoping you'll see here is when you are drafting a smart legal contract, you need to start also asking questions around what could I automate here? Well, where would I get the data from for this? And your tools and platforms should help you with some of these questions. What would trigger this automation? Is there something else that I would automate that fits together? I think of these as Russian dolls. Sometimes if you're going to automate a calculation, that calculation will sit inside an automated notification. Sometimes they go hand in glove. And the last one is around binding. This is not a prescriptive list. I'm sure that as you go along, you're going to ask different questions, but this is things to start thinking about. Let me show you very quickly two more, and then you can we'll move on to Jacques. So here, this is a large company who want to update and change the works plan and construction program. And again, what could be automated here? I could automate a notice. I'll look and see what the data source is. In this instance, the contract itself, generated by the platform, gives you the notice and response notice. And if you look in the content here of this term sheet, they're also referencing a force majeure clause. This is another instance where these automations could be connected. I'm starting to creatively think here, which I've actually seen. Post-COVID, lots of people weren't able to actually call on their force majeure clauses because they had, for example, they had to action the right in 3 or 4 days and then they missed them. Whereas I might say if that had happened to me, well, I actually want to automate my force majeure clauses going forward. So they send me a notice and they do an API call, for example, to the World Health Organization or the Bureau of Meteorology. So that's where I'm starting to think in concepts of automations. What do I want to add? And again, these are probably not binding, but you can see looking at those terms, and this is a term sheet. It's not the actual term itself, but you start to see there is nothing in the content here that needs to be machine readable to feed into this actual content. So it's not the unified method. It's that I'm pairing automations to terms. I'm tagging a term off a set of content. So the natural language is just there as a hook to add an automation. And the last one I'll show you is a rent, an outgoing. So what could I automate in here? I could actually make the contract, I could get the brain of the contract through this automation to do the calculation itself. And again, to issue the notice automatically. And then you've got the invoicing, payment and receipt, and a proof of payment for tax. So again, what's the data source? The contract itself. I've added an automation through the platform to be able to do that calculation. And trigger event, well, it's usually a time-based trigger or recurring payment. And what are the connected automations? Probably my notice of rent calculation. To finalise this part of the presentation, the takeaway is when I'm taking instructions, I'm not just thinking about what happens right this minute. I need to, as someone drafting, start to think about what could happen in the future. How could I use this clever packet of data to start to be able to get the contract to perform more and more parts of itself? And that hopefully I've shown you from these few examples is something when you take instructions, you can already start to incorporate in the way that you approach it. Jacques, you want to go through to the chicken feed example, a procurement example, much more traditional in the smart contract sense.
Absolutely. Let me just share this. Okay, so chickens. So I'm going to take you on a whirlwind tour under the hood of an automated clause. So what you see on screen, obviously besides the beautiful hen, is a description of the clause we want to automate. The term we use for this version is the natural language, and obviously Natasha's been using that throughout. And this is the traditional form of a contract. We're going to turn this into an automated smart clause, which would form part of the smart legal contract, or SLC. As you can see, we're dealing here with the contract for the purchase of chicken feed supply agreement, or FSA. As part of this transaction, the buyer has agreed to a take or pay provision where they must purchase 50,000 tonnes. Sure. Sorry about that. 50,000 tonnes of feed per year, or pay a reconciliation payment calculated by multiplying a margin charge by any shortfall. The margin charge increases over the life of the contract, and that's set out in Appendix 1 to the traditional contract. And for reasons that will remain mysterious, the margin charge is denominated in Hong Kong dollars, while the reconciliation payment must be paid in Australian dollars, just to give us something to do. So for the purposes of our example, the parties have agreed to the form of the contract, including the automated parts, which are running on Clause. As many of you know, Clause is a platform for running smart legal contracts, and it's one of the few that is publicly available. So we've chosen to use it for this example. The smart clause we're going to look at is powered by two primary technologies, the Clause platform and the Accord project template. The Accord project provides a format for smart legal contracts, and it's represented by that triangle showing the relationships between the various files that make up an Accord contract, and we'll get to that in a moment. Clause provides the infrastructure to run or host an Accord contract. It runs the code of the contract, handles the inputs, interacts with third-party systems, and holds the data. Each Accord contract contains at least 3 separate files. The contract text, which contains the human-readable natural language, a logic file written in Diogo language, which contains machine-executable code that enables the automation, and a model file which defines the variables and data types of the data used in the contract. Now we'll look at the reconciliation payment clause of our FSA drafted as an Accord contract. The first part is the text. And within the text, there are 2 files that are included, the grammar and the contract text. The grammar file is a contract template, a generic version of the clause where all of the data elements that may change from contract to contract are specified as placeholders. We call these variables. You can think of the grammar file as a precedent with the variables, which you see here as blue text in double curly braces, acting as placeholders for the data, which is specific to the particular contract. Unlike a traditional precedent, where a lawyer fills in the specifics, the platform will fill these in for us with the relevant data. The variables will be used for calculations in the contract logic and to define the elements of the contract that are specific to the contract, for example, the parties, the key dates, rates, prices, etc. In effect, the variables take the place of many of the terms that are defined in a traditional contract and those specified in the contract details section and other schedules. The contract text file, on the other hand, contains the text of the contract that has been agreed to by the parties. As we can see from the colored boxes on the slide, the specific values in the contract text align to the variables specified in the grammar. You can see, for example, the red box there around supplier at the top with the curly braces is replaced in the contract text by feeder co, the actual name of our party. And we'll talk about where they come from in the next slide. First, we need to define a data model. This is done in a separate file that contains the structure of the data used in the contract. This data model defines the variables, sets the data type of each variable, and collects them into an object. For example, the colored boxes at the bottom of the slide define an asset called a feed supply agreement template. This asset is made up of all the variables that we had in the grammar template. So as you can see, the red box again aligns with the name of the supplier party. This model also contains the data types, which are the words to the left of each item. The data types specify the type of data that can be stored in each named variable, which then defines the type of functions that can be executed on them in the logic file. For example, integers and doubles, which are numbers, can have mathematical operations performed on them, and strings, which are strings of characters, numbers, letters, and so on, can have text processing functions performed on them. As contract variables, the model file defines the more complex data structures used in the logic file. For example, the transactions, which are highlighted in the larger box at the top of the slide, define the interface of the contract, forming how the contract interacts with the outside world. Requests are how we ask the contract to do something, and responses are how the contract can respond to a request. while these request and response models set out the data that must be used when using those transactions, the logic is dealt with in a separate file. So here, if you want to know the termination eligibility, you need to provide the contract year, the actual purchase amount, and the Australian and Hong Kong dollar rates. This is contained within that first box, the first transaction at the top of the page. You can see that those variables are specified. The logic in the separate file will then specify a series of operations on that data, which will provide the response in the form of a string containing the reconciliation payment message. You can see that response transaction being the second one in the large box. Now we'll have a look at the completed contract text in the first box up there, which is generated from the grammar file with the variables replaced by the values specific to this contract, which you can see in the second box. So that is a data file, which is in a JSON format and setting out all of the variables and their values, and it is aligned to the structure that we've just set out in the data model. So you can see there the first variable is the supplier party. So that was the first variable that was part of the main transaction, and the data type for that was accord party. Accord party, unlike a string or an integer, is a complex data type that is defined by a separate standard accord class. It is created by supplying a party ID, which in this case is a string of text, and we've called it feeder code. So that first and second variable, the second one being the customer, called Chicken Farm Limited, are both of the same data type, being accord party. The remainder of the variables are the simple data types. For example, the subject matter is a string, which again is an arbitrary set of characters. In this case, we've chosen feed to denote the subject matter of this contract, being chicken feed. Reconciliation payment limitation days is an integer, and it's specified as 30, and so on. So that's the data in a data file, which when combined with the contract template creates the contract text you see above. So now we've seen how the smart clause is defined, and we've discussed requests, responses, and state objects. Before we move on, let's have a look at how those objects, the contract text, and the model work together. Each accord contract is brought into existence when the contract template is filled in with those specific data and is electronically signed by both parties, a process called instantiation. Once the contract has been instantiated, more complex operations can be performed. Requests and responses are the way that an accord contract interacts with the world. Requests provide the prompts, which trigger certain functionality, and responses are the outputs, which contain the results of that functionality. The state of the contract holds data that has been established by the contract operating. Think of it like the contract's long-term memory. So, for example, the state would record when the contract is signed, transactions made under the contract, such as the sale and purchase of chicken feed in our case, whether products have been delivered, etc. As the contract runs, the state is updated, and data from the state can be used as inputs to the contract to determine further functionality. The contract can also emit obligations, which are another type of object, like responses. Obligations are essentially calls to action for specific parties, for example, a requirement to pay a fee in response to a contractual event. However, it is the logic that actually brings the contract to life by allowing for requests to be responded to, for responses to be issued, and for the state to be updated. The logic file contains the code which determines how valid requests are responded to, how the state is queried and updated, and the content of any responses and obligations. So let's zoom now into the contract execution part of this slide. Look at it in more detail. We're going to look at how our reconciliation payment is dealt with. The sender box is the contract instance, made up of the data model, contract text, and logic file. Here we're representing the logic by this flowchart. In reality, it would be represented by ergo code, but we won't go into that here. The contract logic shows the key question for our reconciliation payment clause, and that is the actual amount of feed purchased over the course of the contract year, larger or smaller than the required amount of feed to be purchased? If the actual amount purchased is higher, or at least equal to the amount required to be purchased, then no reconciliation payment is payable. But if the actual amount purchased is lower, then Chicken Farm has to pay reconciliation payment by reference to the shortfall. So to get this, as we saw in our earlier natural language, we multiply the shortfall by the margin charge for that particular contract year. Now, the contract needs to know when to run this logic. It needs to be triggered by a request, and the request needs to provide the inputs that are necessary to calculate the output. You can see that the request in the red box on the left, which contains the data inputs required for that request. For our logic, we need 3 inputs. The first is the contract year, so we know which margin charge to apply. The second is the applicable exchange rates, because, as you recall, the margin charge is denominated in Hong Kong dollars, but the reconciliation payment or the output needs to be in Australian dollars. So we need the rates to do that conversion. Now, as you can see, the request provides those 2 inputs. However, the third input is the record of how much feed has been purchased, and this comes from the state. This is the information the system has been collecting as the contract has been performed. So the contract already knows this information. But with those inputs, the logic will return a response and potentially also an obligation. Here we have a response that outputs a message indicating how much is owed as a reconciliation payment, if anything. This output message can be used as the basis for a real-world output, such as an email. The other output is the payment obligation, which holds the amount owed and the deadline for that party to make payment. Shows where the inputs are provided in the contract workflow. But where does the contract get them in the first place? On this slide, we're going to go through the interactions between the clause platform, the Accord contract, and the external world. What we're looking at is a point where the contract has been operating for some time. So the state contains information about transactions and other events that have been performed over that time. We can imagine that each party has an interface represented by the web form here, and the parties are able to interact with the contract through that interface to make orders, confirm payments, receipt of delivery, etc. The web interface is outside the clause platform, providing a more user-friendly way for the parties to interact with the contract. We're running through an example of how this would all operate together to calculate the reconciliation payment. One of the necessary inputs for their calculation is already stored in the state, the actual amount of feed that has been purchased. The other 2 inputs, the contract year and the exchange rate, we need to get from external sources. So if we go to step 1 in this picture, we imagine FeederCo wants to check whether a reconciliation payment is due. It has access to its web interface and presses a button to trigger that request. When that button is pressed, it sends a message to Clause, the platform where the SLC lives. Along with that message, the web interface sends the date for which the reconciliation payment is to be calculated. And from this, relevant contract year can be determined. Once Clause receives the message, Clause has defined action flows, represented here by that arrow. They are set up separately, and I'll show an example on the following slides. But in this case, we've told the action flow that once it receives the message from the web form, go ahead and also retrieve the latest exchange rates from the other external data input. As part of that action flow, we've identified an API from which Clause can go and get those exchange rates. So Clause makes a request itself to this external API and receives a response containing the exchange rates. Now we have the contract year input, we have the exchange rates input, and we reach step 3. This is just a data processing step that takes those inputs and ensures they're in the correct format. Next, we send that data into step 4, which calls the request and response transactions we defined earlier in the model file. These then trigger the logic that was represented by the flowchart we looked at in the previous slide and produces the result, being a message and, if necessary, payment obligations. And then step 5 is another predefined action flow, in this case, wrapping up that message and sending it as an email to FeederCo, which requested the reconciliation payment check. So that's an overview of how a party can interact with this clause, triggering a calculation, the clause logic, which refers to data obtained both externally and internally. I'll now go through a few of the missing pieces that show how the Accord files we looked at earlier are put in place on the clause platform. This shows the clause interface where we are creating a new contract. You can see the contract text there in the center, as well as the data on the right, that is combined with the grammar file to produce that text. So that's how the new contract is created. I mentioned action flows before. They took requests from the parties, collected data from an external API, and triggered transactions, requests and responses in the Accord contract itself. This shows how those action flows are set up. Here, the exchange rate API is referred to by the URL and other parameters that tell clause how to interact with that API. The second step there generates the request, which will be used to trigger the reconciliation payment calculation. You can see that the contract year comes from the output of a previous step, and the exchange rates come from the output of step 1, the interaction with the exchange rate API. And finally, here is the action that sets up the notification email at the end of this workflow. This step takes the output from a previous step that contains the output message generated by the clause logic, the response, and sends it as an email to a predefined recipient. Now we're looking at a screenshot of how the contract looks when it's running on the clause platform. At this point, some transactions have been complete, and looking at the contract state, which is in the bottom right-hand corner, and you can see it's just a data structure, we can see that 40,000 tons of feed have been purchased at this point. If you look at that data structure and you go down to feed to date, this is a variable that's been defined elsewhere in the logic that's part of this contract as something to be updated with each transaction to maintain the current amount of feed that has been purchased. So here we can imagine that there's been a series of transactions that have resulted in 40,000 tons having been ordered. Move to, so I talked before about web interfaces. This is the buyer's dashboard. This is one of those web interfaces, and it's not part of the clause contract, but it uses the contract and predefined action flows on clause to interact with the contract in a more user-friendly way. So obviously what we saw before is the bare clause interface, and as you saw with the way the data is presented, it's not particularly user-friendly to well, lawyers and contract managers and other people who perhaps aren't as comfortable with coding and JSON files. So what will happen is that a law firm or maybe one of the parties themselves will, once they've got, as part of setting up a smart legal contract, they will have a web interface defined. Now, what we're showing here is, of course, a very simple one, but of course, they could get as complex as you want. And the big thing is that the information there is taken from the contract, which is mutually agreed to be the actual record of the data. That is, this is not a matter of one party keeping its own set of books during the performance of the contract, which might be wrong or might be out of sync with the other parties, leading to disagreements. The parties during the negotiation of the contract agree on exactly how the data is going to be recorded. The data sources, for example, in this case, the exchange rate data sources that are going to be used. You can imagine CPI data sources and weather data sources for all sorts of contractual events. They've agreed on how that's going to happen. And then once the contract processes an event or a transaction that is written out to the state, which is agreed to be the record. So that should reduce disputes. In this interface, you can see at the bottom, there's been 3 purchase transactions that have been completed, and they add up to 40,000 tons in total, which is the amount that was recorded in the state. This information, as I said, is pulled from the contract for display in the web interface. It would be available to both parties, but the buyer has chosen to have it displayed here on his dashboard, as this is the information it's interested in. And you can also see the ability to make new purchase orders by specifying the amount and pressing the Submit Purchase Order button there. That would trigger other predefined action steps, which are not the ones we looked at before, but they would call a purchase transaction within the contract, record that transaction on the state. And finally, we have the seller's dashboard. So stepping into the shoes of the seller, feed code, you can see a simple interface showing that in that contract and some information about it, the fact that it's active. And the main thing that they want on that dashboard is to be able to check on whether a reconciliation payment is owing. So if they want to know, they press that button, and that triggers the process that we saw before. Now, the final part of that process, of course, was sending out of an email. So in this case, because the Chicken Farm Limited is contracted to purchase 50,000 tons, and in the relevant year it only purchased 40,000, and FeedCo is entitled to a payment, and the email sets out the calculation and the relevant details saying that that it is entitled to that payment. So the novel aspect here is that the email output has been created based on the legal rights and obligations set out in the mutually agreed automations. Obviously, the actual the events that have been generated by these programs interacting on the platform, it's not particularly exciting. You press a button, you get a result. Happens every day. But what's important is, again, that this is generated by the parties' mutually agreed legal rights and obligations. It hasn't gone, there's no room for disagreement, at least on the predefined series of actions. So, of course, there are other ways that an SLC may create real-world outputs. This is a very simple one, the notification, though I think very important and more important in the early days of smart legal contracts. As parties get to trust smart legal contracts more and more, then we can imagine that they'll skip over this step, for example, and they could just connect up clause, in this case, to a bank web service or an API, and you'd actually be able to have that payment made automatically instead of waiting on the parties to do it themselves. So that is the end of that tour, and hope you got something out of it. It's a little bit complicated. There's obviously lots of bits and pieces. I will hand back over to Natasha now.
Thanks, Jacques. We'll try to answer some of the questions that have been coming through in the chat at the same time. So, Jacques, if you could just move to the next section. So, look, the reality is that for many people, what you've just seen is too complicated for adoption. So if you fall into one of the categories of people who looked at that and thought, I can't do that, then you're not alone. One of the reasons that we've used the Accord tool in this instance, it is the most advanced smart legal contract tool currently available in the market. It doesn't have the coexisting plumbing that we've discussed as thinking that is best practice. The other reason we've used Accord is because it's recently been purchased by DocuSign. So it's obviously meeting some of those enterprise features, and it's definitely, Peter Hunt's leading that. It's a really great project. But I would say that most of you may find, unless you have a computer science background, that it's a little bit intimidating to use as a product. Where we get to next is we say, and this is coming from some of the questions like, well, how do you resolve an error? Is that you should expect there to be malfunctions in code. You need to talk. The reason that smart contracts just self-executing code are never going to cut it for what we do as lawyers is that you need to add rules, natural language rules to the game. And this section is about those natural language rules that we think you need to add to the game to make your all that code you've added in consistent and identifiable of how people should behave in respect of it. So taking a step back, when I upload a natural language contract to a smart legal contract platform, it already becomes noughts and ones, and the common parlance for that is machine readable. So I don't need to add any fancy automations. I don't need to create an automated payment or an automated notification. The very act of digitizing the contract or making it machine readable means it has code sitting behind it. The second way, and if you do that, you're already in a position where you're going to need to start to add some Blackletter language to your contract to accommodate what you've just done. The second thing is when you start adding automations, there are more complex Blackletter terms that we would suggest that you would start to include in order to deal with problems that are going to take place when you start adding code and starting to have the contract perform itself post-execution. So there's a few things here and we're running out of time, but I want to introduce the concept of a conjoined clause. Conjoined clauses are not as useful when you have the unified method. That is, the code is the natural language term. They're one and the same. But I'll just share my screen here. A conjoined term is when you have a natural language term. Remember how we kept on the, when we looked at the term sheet, you had some terms of a natural language term, but I tagged that term to add some automation to it. That's what we call a conjoint clause. You have natural language and you tie it to an automation. They don't have to be the exact same term. And if you look at my screen here, what we do here is we say, well, make a gateway choice and say which one of these is capable of breach. So the conjoint term is basically, it facilitates execution of the primary term and allows people to expect that your code will fail And just because my code or my automation fails, it doesn't mean I want to breach my primary term, which is for for parties to have rights and obligations. I don't want to add an automation. Automation doesn't take place. There's a problem with the back-end system. By creating a conjoint clause, I allow people still to be able to deliver something or to do something in an old-fashioned analog way, and I don't breach just because the code fails. So that's a really a method that we thought that we might see in the future. Now I'll just flick my pages to 28. I'm using a paper here that is you will see, if you're interested in these things, there's a textbook coming out from Oxford University Press in November, and there's more detail around these Blackletter questions sitting inside that book. Okay, so some of the changes that we would anticipate seeing, and you guys will come up with more, you'll create your own, is you're definitely going to need to see some changes in the definition sections. For example, adding elements like machine readable or incorporated code. We talk about incorporated code to talk about those automations you're adding, not just the fact that your whole document is now digitized. And coming back to that question I saw before, say, for example, I've added a definition here for malfunctioning agreement code. I've tried to describe those situations in which we think there's an outcome that has resulted that we didn't anticipate resulting, and how to deal with that. We use this definition to ground malfunction. Then also, if you look here, there will also be changes. I'm going to go very quickly here, so forgive me for talking too quickly. That will also, you'll need to add some information about what your data sources are, your data source parties, your malfunctioning data source, what that means. And then here in your interpretation section, we'd expect you to also need to make some changes. And for example, you might need to talk about what the expectations or your cybersecurity standard of your platform is going to be. That will assist you with interoperability if you want to change your contract from one party to another one. And then, of course, you may also want to add in an interpretation and order of precedence. So if you don't use the conjoint clause method, or you want to do it on an overarching schema, you might say, okay, whenever there's an issue between my natural language and my code, I would like people to look at the natural language first to determine whether there's been a breach of this agreement, which we can see here. And going at a very fast pace, last but not least, sorry guys, I told myself I wouldn't scroll in front of you, but I have. Yeah, so the other ones is around data management architecture. Okay, forgive me. This is very poor form to scroll in a presentation. Here they are. Okay, so malfunctioning code and data source provision, I would expect you to have an explicit clause inside your contract that deals with that problem. It doesn't matter if you have malfunctioning code. What it matters is that you've actually determined between the parties in an agreed way what is going to happen when the code malfunctions, i.e. is it a breach? Is it not a breach? Who's going to rectify it? Are you going to just add an equal and opposite reaction to undo something, or what do you expect to happen? Same for unintended variations. You're also going to need to have a term on your data management architecture, and that's, you know, you need to make sure we don't know what's ahead of us. Are there going to be regulatory requirements around this critical infrastructure? Potentially at some point in the future, yes. And again, if you're dealing with corporate data to meet legal duty requirements and corporate directors' duties, I would suggest that your contracts, because they're so important, that you're going to need to have certain standards of cybersecurity in your platform, and your ISO standards, for example, to be maintained over the life cycle of the contract. And the last word you'll see there is choice of platform is as significant as choice of governing law. That's the world that's ahead of us. So I think that's it from us.
Natasha and Jacques, on behalf of the Australian Society for Computers and the Law, thank you for delivering such an informative and practical masterclass, demystifying smart legal contracts and sharing your expertise and learnings with us today. Undoubtedly, you will continue to push boundaries and shape the future of contracting. Very inspiring. Our next event will be Future Payments, The Brave New World of Money with guests from the Reserve Bank of Australia, the University of New South Wales and Mills Oakley. Join our community by subscribing today. I'm Natalia Sinamarkovic. We look forward to your company for future events.